Okay, so greetings, fellow human rights enthusiasts, and welcome back to one of our regional webinars from Asia Alliance Against Torture, or for short, A3T. I'm Nadine Shirani, here as your moderator, who will handle the running of today's event or webinar. And based on its mandate, just to give a little bit of a briefing, A3T is a collaborative movement from Asia Pacific CSOs to press and also to advocate torture cases in their own respective countries and Asia as a whole also. And one of our programs to do so is to initiate or to conduct what we call A3T regional webinars in order to educate and also to give further information to the Asia audience regarding torture cases and their variety of cases. So the theme or the main question as we have seen from Contrast's social media, from the other CSO social media, and also A3T social media, the poster is set that we're going to discuss about torture in detention cells throughout the legal perspective. Now, as a background, it is a common knowledge for us to know that we have UNCAT, or the UN Convention Against Torture, as our main legal protection from all sorts of torture, intimidation, let it be from the severe mental or physical pain or suffering, and then intentional inflicted torture actions, or even the acts to punish, intimidate, coerce, and to obtain a confession or information based on torture acts, and also to instigate a person in a official capacity. Now, this elaboration made and derived from Redress Trust in 2017, the condition for torture today seems to have deviated or worsened from the previous mentioned elaboration. And we see that the police brutality cases kept on coming to give press charges to unarmed civilians, and then the criminalization towards groups like activists and also HRDs, and not to mention the arbitrary arrest, which led to also torture acts to the civilians from the security officers, border security officers, you name it, and etc. So today, the highlight or the main dish, the main course for our headline, you may say, is that torture happening in detention cells. And the red string for our discussion today is how the legal sides perceive such acts of torture in detention cells. Now, moving on to today's agenda, I will call for our several speakers for our agenda today. First, I would like to say hi and also to call upon Mr. Dulan Dasayanaka from the Right to Life Human Rights Center in Sri Lanka. Hi, Mr. Dulan. Okay, pleased to meet you, Mr. Dulan. And next, I would like to call upon Miss Noi Noi from the Cross Cultural Foundation of Thailand. Hi, Miss Noi Noi.
Hi.
Okay, we have Miss Noi Noi here also, and also we have Miss Farida Muhammad from Suara Malaysia. Hello, Miss Farida.
Hello. So,
Okay.
but I'm so sorry because I still lost my video.
Yeah, it's okay.
I'm still working on it.
No worries, no worries. We can just move on to our discussions. Okay, so for our main agenda, here, me as the moderator will ask several questions, 4 questions in total, to our speakers today regarding our theme, torture in detention and legal perspective. So just moving on to our first question for today. I would like to ask first to Mr. Dulan and then next to Miss Farida, and last I would like to save the best for the last for Miss Noi Noi. Okay, so first,
Okay.
the question is, what is actually happening in your country in terms of torture in detention centers? And what are actually the trends of those tortures? So moving on to first, Mr. Dulan, based on my findings and research from the OHCSR in 2017, it seems that there was an observation by the outsiders who have no complete access to give coverage to the detainees. And the detainees also told them that they should not speak too loud on how they were treated in the detention cells. Why is that? And what are the possible torture acts happen within that time and also connected with the time today? So please, Mr. Dulan, the floor is yours.
Yes, thank you for the opportunity given me, first of all. And there are torture, I think in the Sri Lankan context, torture is still prevailing matter. And it's not solved by legislations. You know, there are several legislations in Sri Lanka to prevent torture. But it's in the not only in the detention centers, it's in the open society also. Torture, it's done by officers, state officers, police officers, and others also. And in the context of detention centers, it's really deteriorating, I think. It's not good. It's because the open society has contained, open society reveals torture, contains torture, and they accept torture. So when it comes to the detention centers, it's a really mess. You know. In the Human Rights Commission of Sri Lanka did a comprehensive research on the prison conditions of Sri Lanka, especially the prisons, right? But it's revealed the conditions and also the torturing and the mental and physical torturing on detainees. They revealed a lot of facts about the torture on detainees, especially not only the physical and also the mental torture. Mental torture means it's the condition also, the prison and detention centers conditions also create mental torture for them. And that's the issue. And the most important thing is the remand prisons, means those who are not convicted as the prisoners, as the criminals, so they are under review in the remand prisons, because they also face to this kind of deteriorating conditions and also the some kind of torture, because it's I think it's not a good thing, because in the Sri Lankan context, the remand prisons are most remand prisons are worse than other prisons, right? Because and I can give an example also how the state officers treat prisoners. The person who all the prison ministry, I mean, the minister of prisons, he's the person who responsible of the prisoners, and he's the person who has to look after the prisoners, and also it's he's the person who has the responsibility to upgrade the prisons and detention centers as well. The person who earlier he went to the one prison and asked PTA detainees to kneel down in front of him. It's a really issue in the Sri Lanka at that time, and the government, the president has to ask him to resign, right, from the ministerial post. That's the condition. I mean, it's a very good example to consider how they treat prisoners. You know, how do they treat prisoners and also all detainees, right? And the latest situation, the latest incident is comes from the Ipcc, the rural area in very close to down south in Sri Lanka. The prison in Ipcc, there are the latest murder happened in there. This murder happened after the torture. This is a torture directed to the killing of prisoners. All the legal matters are still going on, and in earlier, you mentioned the COVID situation. The COVID situation is very bad to affected very bad to detention centers in Sri Lanka. The one very grave situation happened. The worst situation happened in the prison in Mahara. The Mahara is very close to Colombo. Right? It's not a very remote area. It's very close to Colombo in the western province. Right? What happened there? The prisoners and also the remand prisoners and all the detainees make a struggle against the lack of facilities to prevent from COVID, because they have lack of facilities and lack of spaces. They struggle because all that the 1 year before 1 year the COVID is very people think it's a very people think it's serious. Prisoners also there, and the overcrowding is a major issue in Sri Lankan prisons. Therefore, the 1 meter space and all the things are not there in the prisons, right? Therefore the prisoners have had some agitation. They are because they want some free space to prevent from COVID, and there are some rumors. Some prisoners infected with COVID, and those things happens. And what happened? Well, how the state prisons officials react it? It's a very brutal manner, and then they fight. They hit them first. They started the hit, and they shoot them. What happened? There are several prisoners, more than 10, killed by them, the detainees inside the prison. Finally, they try to express to society. It's a struggle between the prisoners, in between the prisoners, not them, but some CCTV footage and a lot of examinations, investigations happen, and also the first committee also revealed, the first committee appointed by the president revealed there were some officers shot them, but still they didn't receive justice. And also, when the COVID situation started in Sri Lanka, the Anuradhapura, the prison in Anuradhapura, it's also some kind of a remote area, but it's a center of the north central province in Sri Lanka. The prison in Anuradhapura also had that kind of agitation, and how the state officials react by shooting them, and 2 prisoners were killed there. Right, in the I think this 2-3 years there are several prisoners were killed. Not I think it's the torture. First, the torture directed to killing of these prisoners. It's not they not even torturing them. They even do not hesitate to kill them. I think, right? That's the situation in the detention centers, and especially the prisons, because prisons and remand prisons are the most common detention centers in Sri Lanka, because a lot of people are detained there, right? And the others are also, PTA, Prevention of Terrorism Act. It's a huge issue in Sri Lanka. It's I think it's not according to the human rights. It's against the human rights, that the Prevention of Terrorism Act. Its act was passed in 1979, but still, as 1979, it's passed as a temporary provisions, but it's still continue up to now, after the brutal war ended in 2009. They continue it. Now it's almost 20 years. They almost 10 years. They not almost more than 10 years. 10 years they continue this PTA, and they used it to suppress some kind of people without producing them to judicial authority. And the PTA detainees also in the prisons, also detained in the prisons in Sri Lanka. And also the recent incident, the civil society activist and the person who works on consumer rights, Mr. Asela Sampath, also remanded to some kind of issues, and he revealed, and after he came out, and he revealed a lot of things in the prisons, because how they treated them to enter into the prisons. How when they enter into prison, they first they started by torturing or some kind of pole or something, and they hit first in the first instance. That's the situation. It's a really bad situation, and the situation is
Hello, Mr. Dulan. I think Mr. Dulan has
burst because the overcrowding. Yes.
Yeah.
Sounds okay.
Yeah, I think you have lost your connection in just a matter of seconds, but it's okay. Continue on.
Okay. The first, the problem is the people also think that torturing is a better way to treat them. That's in Sri Lanka we've been able to change the people's mind, common people's mind. That's a failure. I think that's some kind of failure of civil society as well, because we recommend the government to several legislations on torture and on the prison conditions and all the things. We achieved that. We have a lot of laws. We have fundamental rights and other criminal laws, and also I'll explain in the next part. I'll explain what are the laws in here. There are several and fully fledged law in Sri Lanka against torture, but the torture is prevailing because it's over time it's people's consent. Sometimes people's consent is with the torture, I think, according to my knowledge, because people think some criminal activities can solve by beating them, by torturing them, and by punish them in a grave manner. That's the people's thinkings. And also the prison in the detention centers condition in the context of detention centers, I can say that situation is the torturing is there, torture is there, and the situation is worst because of the prison conditions, and overcrowding of prisons is a major issue in Sri Lanka. So we don't have several modern prisons, because in the as I said, in the HRCSL, Human Rights Commission's report, it's a very comprehensive report. They shown us some photos and all the things in the Colombo prisons, Valikada and Magazine prisons. It's in the heart of the Colombo, and Bogambar in the central province, and there are so many prisons, but we don't have good modern conditions in prisons. And overcrowding means in some kind of in very small cells there are 20 detainees. There are 20 detainees. It's a it can't be there actually. In the situation is more than serious in the remand prisons, because remandees are in a number, remandees are very high, more than prisoners in Sri Lanka, because in the court delay and all the things is there, because of the justice delays and court delays. Several people has to stay in the remand prisons 1, 2, 3 years. Therefore, there are so many remand prisons also here, and so crowded in the remand prisons also. And the facilities, the water facilities, sanitation facilities, and all the things are not good. It's in the bad conditions. Therefore, the torturing is already there. The torturing is there by these conditions. No, it's no need to torture by officer. The conditions also makes some kind of torture there, and the mental and physical also, because the person who can't do his sanitation activities in a proper manner, I think it's a torture, right? It's because government is not trying to change this situation. Even fulfill their sanitation activities. Even government is not trying to upgrade their sanitation facilities. So I think it's a torture, and also not only the physical and mental also, and they don't have facilities to read in and all the things, and some kind of activities. That makes torture. It's only one prison they created in rural area in Ipcc, with the international recommendations, but we heard now it's also going to be overcrowded, right? That's the issue in Sri Lanka, overcrowded, and all the facilities makes torture, and that is the situation in Sri Lanka. I think I'll explain next turn the legislation and its impact against torture, and why it's did not impact to prevent and to eliminate torture in Sri Lanka. Why this? Okay, thank you.
Sure. Thank you very much, Mr. Dulan. So Mr. Dulan here has highlighted several acts of torture, not in the sense of only by hitting to the point of killing the detainees, but also by giving them such sense of uncomfort in the detention cells, like they're overcrowded, and then there are no maybe mental necessities tools to keep them, sane and etc. So, and there are also a lot of acts that have been mentioned by Mr. Dulan. Here, maybe I will point out later on the next question, since you have mentioned the temporary provisions in 2009 for its law of torture, and if it's still continuing or not, and if it's still able to prevent such acts of torture or not, but we'll get to that later. I will now pass the microphone to Ms. Farida for the question. Since I've seen that in Malaysia, especially Swaram, have a campaign to pressure or to press the Malaysian parliament, because there has been death cases in detention cells starting from 2021, or I don't know if it's starting from before those times. Can you please elaborate more on this, Ms. Farida?
Okay, thank you, Nadine. All right. So like if you notice that lately in the news, there's cases of death in custody has been increasing, and actually recently, like there's a department been established in the police force to so-called like investigate the death in custody cases in police detention, because like previously, before the setting up of the department, all cases involving like death in custody, in police custody, is investigated by the same police station where the where the incident occur. Although that's like there is we must admit there's some improvement in that sense, but somehow when we see there is more cases like, happen like, almost every week. So it raised the question whether like, is it, is it like, there are many, death in custody occur that we don't know, or it seems like, well, the police is like, not really like, disclosing the fact to the public. Okay, then for the purpose of today's discussion, so maybe like, I can like categorize like, there's 3 detention like, facilities in Malaysia. We have police lockup and immigration detention center, and also prison. So for police lockup is where this person or suspect of a criminal offence has been detained for remand for the purpose of investigation. So for under common or normal criminal like cases, the detention can be like, from 1 day up to 14 days. And there are also detention under special law, or in other words, preventive detention. For instance, like we have Security Offences Special Measures Act, or we call SOSMA, which allow the police to detain the suspect for investigation up to 28 days without getting a remand order from the magistrate. So it's a police who's like, of a high rank, of a rank of superintendent and above, can give an instruction to detain the suspect of that fall under this category of security offences to be detained in the police facility up to 28 days. And then we also have like Prevention of Crime Act, which allowed detention for investigation up to 60 days. So this is mostly related to organized crime, gangsterism. And also another law is Prevention of Terrorism Act, which also allow detention up to 60 days. I think it's more or less similar like what we have in Sri Lanka that presented by Mr. Dolan just now. And also there's another law in relation to drug syndicate, which is like Dangerous Drug Act, Special Preventive Measure. So this also like allow detention for investigation up to 60 days. And so bearing in mind that this, the 3 laws that I mentioned about, the preventive law, it's allowed detention without trial. So there's no charge in court. So basically after the investigation, then there will be a board appointed under the respective statutory provision will determine whether this suspect could be detained further under detention order up to 2 years, which subject to renewal, or to be banished out of the their residence. We call it restriction order. And then about the immigration detention center, well, those migrant and refugees who are like suspected or arrested for going against the immigration law, for having like irregular documentation or anything, any offences that contained in the Immigration Act, they could be remanded up to 14 days, which is allowed by the law and also the Constitution. It is for the purpose of verification of their status and for the immigration authorities to verify their documentation, the validity of documents and whatnot. And for those who've been like been charged under the immigration offence will be sentenced to prison, and also later will be put in the immigration detention center pending deportation. And lastly, prison is where the individuals who are sentenced or convicted been put to to serve their sentence, and it's under the purview of the prison authority, prison department. And also is a detention facility for those who are sentenced with death penalty pending execution. And another category of the prisoner is those who have been remanded upon being charged in court for the non-bailable offence like serious offences, for instance murder or drug cases, or terrorism cases, and also for those who can't afford to to pay the bail amount, and then they will be detained pending this disposal of the case in court. So like most of the cases, like incident of torture happen in the police lockup, where like where is the place where these people are being detained for investigation and interrogation. So the police will like use it's either physical torture or mental torture against this suspect for the purpose of extracting confession. Yeah, for instance, like it's always like this case is really rampant in preventive detention related cases, due to the reason that the detention period is like is much longer to compare with like the normal criminal cases. And since it's a law like that allow detention without trial, so on this stage this detainee will be tortured to get the to extract the confession, so that because most of the evidence that will be presented in the board before they got the detention or restriction order is actually most of it based on the confession from this detainee during the remand period, like for the 60 days period. And yeah, like like the case, the report that we got from in Suaram about from the family of the detainee, from the detainee themselves. There are various kind of physical torture. For instance, they've been electrocuted like in the course of interrogation, and like some of them also been humiliated in the sense that they've been they've been forced to strip naked, they've been forced to do like like they're playing with their genital. Okay, so sorry for the graphic information, but somehow yeah, that's what's that's what's been happening. And then they like they also deprive this detainee from getting legal access, although like under the law, like for instance for SOSMA, for example, the police can deny access of counsel up to 48 hours. But usually like during the interrogation or statement taking, it will done without the presence of counsel. And those confession is actually can be tendered in court during trial, in which under the law, the admissibility of the statement is not an issue. And then also there's an issue about delay in giving a medical attention to the suspect who's having like existing medical condition. There are cases like for instance Benedict Tanilas is a elderly man who's having heart condition and also various kind of ailment. And the family was not allowed to, the family already brought the medicine to the, to the lockup for the police to, to give the medicine to the detainee. But somehow it was not given, as a result of which this late Benedict Tanilas died in custody. And also there are like, there are also a few other cases, that resulting, death in custody for omission of like, by the authority to give a medical attention as well. Okay, and then with regard to the Immigration Detention Center, so it's actually like, I must say there's a lot of like, physical abuse happened, but it was not widely reported as much as like, you know, what is happening in prison or police facilities. And apart from that, there's the condition was not sanitary, and also there are lots of like, you know, I mean, people who need like even medical attention, basic needs was not being attended to. And also there's an issue of overcrowding as well. And then lastly about a bit about prison. So although like in comparison with the lockup, the police lockup, the condition is a bit better, but somehow it doesn't mean that there's no ill treatment happen in like, you know, in prison facilities. So like for instance, like for the past 2 years when we like hit by COVID-19, there is a lot of like, you know, I mean, report regarding to the, you know, infection of COVID has been, I mean, that's from, is widespread in the prison facilities. There are many prisons being like, you know, declared as a COVID-19 clusters. So there's an issue about, you know, about overcrowding, and there's no adherence of standard operating procedure or SOP by the prison authorities towards the detainees. I mean, like, you know, they were not like been given a, you know, face mask or hand sanitizer every time they've been like, you know, brought out from the prison, for instance, if they want to go to the court, and then there will be like, and then the issue about medical attention as well, because there are many complaints about there's a lack of, you know, medication being given to the prisoners, and most of the time they've been given paracetamol, and also there are complaints about even paracetamol also is not really accessible to them. And if they are having like a normal flu or they're having cough, they just have to hold it until it becomes serious, then they will bring it to, you know, to the attention to the doctor. And with regard to the death row prisoner, and they've been put in solitary confinement, and there will be like very limited access towards the, you know, I mean, like to have like, you know, physical interaction with other prisoners, and also to have like activities, to have like, you know, recreation, or, and also they are not allowed to have like, you know, to work or to have like, you know, any like program, to involve in any program like other prisoners on the pretext, you know, to control them so that they won't do anything that, you know, for them to take their life before they've been actually executed. So most of the, I mean, the longest hour they can have like, you know, like recreation outside of the cell is 1 hour. And then because of like, you know, having, you know, that kind of like, you know, I mean, treatment and condition, and also agitation of like, you know, thinking about waiting of, you know, them to be executed. So it's actually, it's caused like, you know, mental torture, and there are many instances where this death row prisoner is having like, you know, I mean, depression and develop mental illness before they've been like, you know, before they've been executed, or some cases they've been pardoned by the, you know, by the king, but somehow the prolonged solitary confinement and such treatment in detention is actually cause, you know, take a toll to their mental health. And also in relation to those people who've been detained in prison for terrorism-related offences, whether they are like, you know, being remanded pending the court proceedings being disposed, or those who has been sentenced, you know, who has been found guilty and sentenced. They also issue about, you know, they are not being allowed to have like, you know, attending to programs, prison programs, and also like interaction with like, you know, other prisoners, which also cause like, you know, I mean, has affected their mental, you know, situation as well, because like, you know, they've been perceived as like, you know, a threat to the, you know, security for like, you know, for fear that they will be like, separating the extremist ideology if they like, socializing or meeting people around. But actually, like, in my opinion, and also like Suara also been, highlighting this issue with other CSO as well, it's actually is not, a good way to, to treat this kind of, prisoner, because there are many like, instances where by doing this to them, it's actually radicalizing them further because of, the oppression that they feel when they are, being detained. Okay, so, but for, I think, as far as this question, I've covered like, bit and pieces. So maybe I can like, I elaborate further for the another round of questions as well. Yeah.
Sure thing. Thank you very much, Ms. Farida, for your elaboration. So maybe the same or the similarity of torture in detention center between Malaysia and Sri Lanka is that the overcrowded number of detainees and the lack of health and mental health also facilities in the detention centers, because whether they are from marginalized groups or not, they will still have a certain amount of the lack of access towards the facilities. So, but what's unique from the elaboration is that they are also to be humiliated in the prison cell. And for example, they are being stripped, if I'm not mistaken, there in your elaboration. And then they have also been electrocuted for information and investigation. So there are certain amount of interesting points there from Ms. Farida. Thank you very much. And now I will move on to Noi Noi. Hold on. So hi, Noi Noi. Okay, while Noi Noi is still adjusting her camera, maybe I'll just ask my question right away. So one of my recent findings that there is this media platform to be my main reference for Thailand is that the Al Jazeera written that the Thailand prison have failed to meet the international standards for inmates, for them to be shackled and then beaten and also stuffed into overcrowded, again, the same point as Malaysia and Sri Lanka case, being stuffed into overcrowded cells. So how do you elaborate this and connect it with the recent case of the torture in detention cells today, Noi Noi? Please do.
Yes, can you hear me well?
Yeah, I can hear you.
Yes. Okay. Talking about torture in detentions, I think we also have...
No, so sorry. I think your camera is still tilted.
Ah.
Yeah, your camera is still... yeah.
So...
Yeah. Okay.
Okay, sorry. Talking about the torture in detentions, we also have the situation, of course, as we mentioned about prison conditions, but I think I would also want to talk a bit about before the imprisonment, before enter into the prison. There are also several types of detentions. According to our law, when people get arrested, they have 48 hours that the police shall investigate or shall finishing some preliminary investigation before asking the detention by the court order. So within that 48 hours is a situation where the arrested persons will be kept in the police facilities, and torture might have happened even before enter to the police station, during the transportation, during the crime scene, and also the condition within the prisons. I mean the lockup in the police station also various. And we also found the case of death in that police station had happened also. Not often, but there are some cases. And always been an excuse. For example, the arrested person are hurting each other, or they are committing the suicide. So it also had happened during that time. We also have detention under the martial law and emergency decree in the Deep South that contains 7 days without lawyer or without even the visit from the families. And is also continue with the detention under the emergency decree for 30 days. It could be in the military camps or it could be a police detention. But again, with the special conditions, lawyer access is an issue. They don't need to report the detainees to the third party, for example, the court or other institutions, so they can keep them without communication to the other authorities for maximum of 37 days. So you can see that the risk of ill treatment and also torture, psychological torture also can happen during that day. This, we are talking about the crimes related to terrorism and insurgency in the Deep South. But now we can see that the situation in Bangkok, also in other part of Bangkok, in Thailand, also have giving police and some military to conduct something similar using the emergency decree under the COVID condition, doing similar things to protesters or demonstrators in a group or as individual. So they've been trying to keep them away from lawyer as lawyer, and also away from friends, away from the family. Enough time for them to ask them to stop demonstrations, and also even charge them on some kind of political offenses. We also have the situation of 3-day detention in a safe house under the drug suppression law. That also giving a very harsh condition for drug suspects, offender, to be kept and further giving confessions or giving more information about drug trafficking. And we have a recent case last year that the police officer have used the plastic bag over his head until he passed away at the police station, and it's the video capture, and then it has been spread into the social media. Luckily that we be able to get those 6 officers into the trial, but the trial seemed to be very secret. I mean, we cannot observe the trial, so we do not know exactly what is going on in the trial. So fair trial and things related to torture has been difficult for the victims and for the public to know what is happening or if the justice will be delivered. Talking back to the detention facilities, of course, with those few days under the special measure, torture had happened due to, of course, confession. And because of the Thai law are not absolutely prohibited of torture in the way that torture confession are still using as an exception in the court, but it's good enough for police and military to use torture and confession in the court, especially the cases related to national security, drug suppression, or something like rape or criminal against foreign tourists, you know, because we are relying a lot on tourists. So when there is a criminal case related to tourists or foreigner as a victims, it tends to have torture within the police investigation to finish up the case. And it has been difficult to help the victims because they are in many parts of Bangkok or many parts of Thailand, and we are a small organization, we cannot cover those cases. Maybe we have a lot of things in common with Sri Lanka about the detentions, especially in the prison, overcrowded, and also lacking of facility when we are facing COVID pandemic, and death in custody. A lot of sick prisoners also not access to healthcare, so they die in the prison because of their own sickness, no? And because of deny bail. The bail money in Thailand is very high, and the cases related to national security and also serious crime. Also, the police also deny bail, and at the same time, the judges also reaffirm the bail that cannot be granted, cannot be give it to the prison, to the accused person. In the detentions, we have a lot of story related to ill treatment due to overcrowded, due to lacking of water facility, the light, and also they have been kept in what you call the cell for sleeping overnight, long hours. I mean, we don't actually, the prison in Thailand has become more modern. We have space, but due to the lacking of the staff, so the prisoner was asked to be in the sleeping cell very long hours per day. So that means they have to squeeze each other into the cell with the light on, with the heat, and only 2 toilets for at least for 50 detainees or even more. And the toilets are also not very nice during in the prisons. No? So talking about torture, parallelly, if we looking at the definition of torture under the CAT, the torture in such as practice only happening in the police detention or military detention at the beginning in order to correct information, confessions, and also maybe referring to the other criminals in the same circles or something related to terrorists and insurgency. Torture might not happen in the prison because the prison guard is nothing to do with the investigation. But torture among prisoners also had happened, and it's not dealing with the good oversight mechanism. So sometimes we don't really know what's happening. Why is this prisoner die? And why is this prisoner injured? And the investigation also not transparent. So we cannot stop those things to happen. When the death in custody happen, we have a law that related to inquest. And the inquest supposed to be done by a forensic doctor, prosecutor, and the civilian officer, including police investigator. It has been done properly, but the transparency of those files is not so perfect. So sometimes the cause of the death can be hidden. I mean, we don't really know what is happening. A lot of body were not autopsy. And so the court hearing on the inquest is actually not blinking the truth for the family if they have a doubt about the death in custody. Another issue is about immigration detention. Of course, Thailand has a lot of migrant workers, migrants who come to Thailand. Some of them even should have refugee status even because they are coming from the country of war. But due to that, Thailand is not ratified the Convention for Refugees. So their granted of refugee protection is very difficult. So we kept them by the law of illegal entry is maximum 6 months in the immigration detention. But we can see that there were a lot of people get arrested and a lot of bribery have been happening. So people might be able to leave the detention center of immigration police, but they need to use a lot of money, a lot of connections. And so some certain countries has a good support, like Korea, they're helping North Korea, some of the Western country also providing assistance. But you have a lot of people without any attention. They might spend years in the immigration detention, it is small and overcrowded, and things are lacking of facilities, and a lot of even women, even the elderly, even those who need care in the hospital are still being kept in detention, immigration detentions. I think we have a lot of things in common also with the Malaysian in relation to torture investigation, because we don't have a specific law as yet. But so if the death in custody or torture happen in that locality, and most of the time it's happened by the police who is responsible in that district. So the investigator is the police into that district as well, or in that police station. So the investigation, oversight mechanism over the torture in detention, I think is a common issue among us, these 3 countries of the case studies. I think I'll stop from now, and maybe further for the next question, I can elaborate more on the view as well later. Thank you.
Sure. Thank you so much, Norna. You have also stated there the lack of not only facility, but also the lack of transparency there. So it also focuses on how do we get the data if the transparency is not there. So it is also a big point from Noi. Now, moving on to maybe our next question. Now, maybe for this next question, I would like to limit it only to 6 minutes per speaker, because we still have 2 more questions below, and I don't really want to drain your energy during the weekend. So we'll just take 6 minutes as our limitation of time speaking. And maybe in those limitation of time speaking, I will also maybe set a code when the time ends for you to speak. Okay. For this next question, now based on the elaboration the speakers have mentioned during the last question, are there actually any safeguards based on the UNCAT to your perspective or your respective countries? Like maybe the anti-torture bills, or maybe the applicable law, perhaps. Maybe I would like to go on and give the first 6 minutes to Miss Farida. Miss Farida, you may.
Okay. Right. Can you hear me?
Yeah, I can hear you.
All right. Thank you. Okay. So as for now, that Malaysia has yet to ratify UNCAT, and they are also like campaign by the staged by the CSOs to for the government to ratify UNCAT, but somehow like we cannot see like any positive reaction so far. Yeah, but as at present, like the only like the legislation applicable with regard to torture is only in the the penal code in relation to the causing bodily hurt, causing injury, and when someone is like charged in court, so they will be like going undergo the trial and sentenced accordingly if they found guilty. But it's just a normal like criminal procedure like any other kind of similar crime related to causing hurt or causing injury. And so far, like for when it comes to like case where there's a death in custody, that is resulting from the the omission or positive action by the detaining authority, there is in inquest procedure like stated in our criminal procedure code, and in which like stated that it's mandatory when there's a for the inquest to be held when the death occur in the in detention facilities, which include prison, police lockup, and also mental asylum. But if there's the perpetrator or someone who like, I mean, the person who actually inflicted the injury or caused death has been like, charged in court for criminal offense, so then inquest is no longer, needed. But somehow like at the moment, the Malaysian Bar Council is still working on like, with the government to put forward the Coroner's Act, in which like, it's supposed to be more comprehensive rather than the one that we have, at present right now. But somehow like we'll take some time to, for the thing to be materialized, like, for like at the moment, we also like, I mean, pushing for the Independent Police Complaint and Misconduct Commission Act to be passed in like, in the parliament, because like, previously the bill has been prepared and drafted in 2005, but somehow like, after some time there's a change of government. They plan to, to reintroduce the bill, but it has been watered down. And now it's more disappointing to say that the current government is like pushing for the Independent Police Conduct Commission, or in short Ipcc, which has no like it's like a step backward. We have in which we have a lot of weaknesses, in which like, there's no power, for instance, for search and seizure, this limited power to compel, the documents or the witnesses to come forward. And also they are like, where they have very limited investigation power, in the sense to, to investigate the perpetrator who caused like, death or any misconduct, towards the detainee, or anything in related to the, police, police misconduct in general. Yeah, but so like and with regard to the access to like legal representation in Malaysia, like we have like a legal aid center under the Bar Council, and also there's a legal aid department under under the government department. But somehow the access is quite limited, especially in the rural area. And then there's lack of participation of lawyers who are willing to take up the case voluntarily as well. And also the funding is quite limited, and which causes like lack of interest for lawyers who take up the cases. And then there not so much of publicity by the by the court, and also by the police station or the detention facility as well, about the existence of availability of legal aid for those who've been who are in need for legal counsel to represent them in court or giving legal advice. So there are many instances where this detainee or the suspected person, who are like they don't know like about their legal right. They just like confess towards like whatever that been forced against them. And also there are lack of reporting mechanism when it comes to issue when their right being violated during detention. And at the moment, like what the procedure that available is that for those who've been like been tortured or been been ill-treated during detention, so they should lodge a police report, so that the the incident will be investigated, and then like for the legal action to take course. But somehow like, well, if they're it's kind of like ridiculous to say that you want to lodge a police report against the police, sue the police. So it kind of it's not really make sense, but that's the procedure available. And then like most of the time, this victim they are not they're afraid to come forward or to complain against, you know, the torture inflicted against them, because they don't want, like, you know, in the, you know, the police or any, like, you know, really authority related to the respective police station will harass them or harass their family members. This is really rampant in the rural area.
Okay.
And also the issue of corruption as well, because it's also a common place where the police will extort for, you know, money, especially for those who are, like, you know, migrants or like the rural, you know, the people who live in the rural area, because most of them are, you know, scared with the police. They fear that, you know, the police is, like, you know, is someone with a higher authority. And then if they ask, for instance, if, like, you know, for family member to see, like, you know, their son or daughter who've been arrested in the police lockup. So actually, yeah, they have a right to see, you know, the family member, but somehow the police will ask money in return of the visitation. And it has been a common practice. And well, although it's not a right thing to do, but somehow, like, no one is, like, you know, I mean, willing or, you know, brave enough to come forward to complain against it. Okay. And lack of support as well.
Okay. I think there are still several things that you may elaborate in this question, but maybe you can save those points for our third and fourth question, Ms. Farida.
Yeah, sure.
Yeah, sorry. And now I will move on to Noi Noi. So yeah, regarding the safeguards from the UNCAT towards this case, how do you view it, and are there actually any safeguards for Thailand, especially for the anti-torture bill in Thailand? So you may, Noi Noi.
Yes, I like to share all of the above from Malaysia. That's also happening in Thailand. Or the conditions of things that has been obstacles for the justice or access to justice for torture victims, lack of participation of the lawyer, lack of the evidences, including medication report, lack of public attentions, and also the complaint mechanism is not effective. In Thailand, we have ratified CAT and also signed CED, which is related to enforced disappearances, that make us being pressured by international community to improve the legal framework on prevention and protection of people to all forms of torture and enforced disappearances. We have the criminal code that of course you can arrest police if they hurt you or if they harm you and if they torture you, but it has been difficult to correct evidence, and also difficult that the incident happening many months or year before you are free from detention to go back and trying to launch the complaints, because the complaints by the relatives are often is not effective enough under the Thai law. So access to lawyer in order to facilitate the access to justice also difficult, because the lawyer need to have a very what you call experience in order to deal with the police brutality and in order to help the victims of torture. We have since we ratify CAT and also the CED is that design. So we need to have our domestic law. The bill was drafted by the Ministry of Justice. The proper one is in 2014, but we have the coup d'etat. So the bill actually pending for a long time before we have the cases of Wan Chalerm who went missing in Cambodia. It has started the demonstration in Bangkok. So the bill from the Ministry of Justice, which is criminalizing both torture and enforced disappearances, have come again into the table of the parliament. And then Later, we have the case of the police officer who used a plastic bag over the drug suspect until he died in front of the camera. So the bill again was become public attention, and it has been again being proposed by civil society and the victim family. So right now we have the draft bill which coming into where the parliamentarians of the whole meeting at that time last month alone have approved the bill. So the bill is now passed in the parliament, but because we have the constitutions which drafted by military, the bill or any law that will be effective have to pass the Senate. So now the bill has gone back to the power, which is not transparent. A lot of ex-general is there as the Senate. So it's going to be difficult for us to monitor what's going on with the Senate and whether the bill will come out and not amend and then we being effective. So we have some special measure in this bill that all the arrested officer need to have the camera on their equipment. So to see every act, everything happen during the time of the arrest. And that would also being approved if something had happened that the police officer or any arrested officer did not do anything with the detainees until they die or until they pass out or until they injure. So this evidence is good to prove what exactly happened to the detainee during the time of the arrest. And also the bill mentioned that all the arrests needed to report to the prosecutor and the civilian officer. In the present, the arrest is not informing to other institutions. So the police arrest, the police investigate, the police detain, and then torture had happened. So we want the third party to come and have our information. We also have a number of articles which actually facilitating the investigation. And at the same time, we also have a provision that talking about preventions, the record, the duty of the committee into the search or into the, not the search, into the visit of the detention center. So we have an oversight mechanism. So all of this is the safeguard that we think we will have it more effective to prevent torture to happen in the detention at the time of the arrest until when it had happened, for example, disappearances. So we can have a better investigation and truth for the victims' families. We want to talk also about Nhrc as a last topic on safeguard. We have National Human Rights Commission who have the power to investigate and to receive the complaints and also to visit the detention center. They are not really effective at the moment, but we see that their new batch happened in the past 6-7 months. So I can see that they have attention to do more or better work. Okay. Yeah, sorry, I think.
Yeah.
Hello. Okay.
Yeah, hello.
So I think that's the end of my discussion about safeguard.
Sure.
Yeah, I think that the last part is about National Human Rights Commissions is the thing that we hope that they can do better, and then they can become a real safeguard for us, for everyone to be free from torture.
Okay, sure. Thank you so much, Noi. And you have the perfect amount of time. It's 6 minutes here. So thank you very much, Noi. Okay, so it is actually very interesting for how you not only highlight the safeguards in terms of law, where it's written or not, but also the implementation of the law itself, whether it's still built or it's already implemented. Like the monitoring tool, you said that the camera used by the security officers to monitor whether they have conduct or maybe engage with torture or not to the detainees. So that's also a good example from Thailand to perceive how torture is badly occurred in Thailand and how should they prevent the act. One of the examples is on how the security officers tend to maybe socialize with the detainees. Okay, thank you. And last, maybe we can go to the 6 minutes for Mr. Dulan, because you have also mentioned before there are temporary provisions in 2009, and how does it still connect with today's torture acts, especially in detention centers? Please do, Mr. Dulan.
Yes.
Oh yeah, sorry to remind, just you have 6 minutes for us to pass over the next question. Thank you, Mr. Dulan.
Yes. Now it's okay.
Yeah, it's all good.
Okay. And in the Sri Lankan context, there are several legislation, as I mentioned earlier. Yes. Yes. Okay. And as I mentioned earlier, there are fully fledged, I think, almost fully fledged laws to prevent torture in detention and as well as in the open society. We have ratified the Torture Convention. We have ratified the International Convention Against Torture and implement its legislation through the Act number 22. It's called Act of International Covenant on Preventing Torture. It's passed by the Parliament on 1994. It's very now it's more than 25 years, and also we have fundamental rights in the Constitution. It's under the Article 11. It's indicated the torturing and the inhuman degrading treatments. Not only the citizens and all the persons in Sri Lanka has the liberty to be here free from torture and free from inhuman degrading treatments and cruel treatments, and that's the fundamental rights. And also the penal code in Sri Lanka also mentioned the torture is a criminal offense, and the Torture Act, and I mentioned earlier, it's the Torture Act provides several punishments on torture. It means that the between 7 to 10 years rigorous imprisonment can be ordered by the learned High Court judge under the Torture Act, and also the big compensation. It's earlier it's on only 50,000. Now it's I think 10 lakhs, right? There are laws, in torture. It's in one side, it's a fundamental right. Preventing free from torture is a fundamental rights, and also the torturing is a criminal offense according to the Sri Lankan law. And there are so many, there are very grave punishment those who have doing torture. And also the as mentioned in earlier, our other resource persons, according to our Criminal Procedure Act, the police has to provide the citizens, provide the persons who detain to magistrate, to a judge, to a magistrate within 24 hours. Not only 48, as Nono told. It's within 24 hours they have to produce before a magistrate, and magistrate court is the primary criminal court in Sri Lanka.   that's the law here. But Prevention of Terrorism Act, it makes some difference. It can be, according to that act, the suspect under the Terrorism Act can be detained without producing before magistrate in 3 months, right? It's a that's why I told it's a violation of human rights of the citizens, and these are the laws in Sri Lanka to established to prevent torture here, torture and other inhuman treating ill treatments, right? But the problem is in Sri Lanka, it's our constitution is passed in 1978. The fundamental rights comes since 1978, but the problem is the torture is still prevailing. The situation, you know, as others told, CCTV cameras and all the equipments are there, but the torture also is there. That's the issue. I think in the Sri Lankan context, my view is the people's consent and the people's ideology. It's for torture. You know, it's not against torture because they think the drug trafficking, the drug problem can be solved by killing them and by torturing them, and not through a judicial process. They don't consider about the judicial process. There are issues because of the court delays and justice delays. People's lost their confidence on the judicial system. Therefore, the people think no need to provide them, no need to produce them to magistrate. So to judicial process, it's the best way to do it by the law enforcement officers. Eliminate drug issue by eliminating the suspects, right? That's the people thinking. And also the under the under very in the school age also, the people think if they want to build up a good child, they have to beat and prepare a child as a good child. The Sri Lankan teachers has a consent from the people to beat their child. That's the issue. The people, commonly in the Sri Lanka, the people's consent is for the torturing, especially in the detention centers. Detention centers, the prisoners and others, the people think they are bored. So in front of the prison, they indicate prisoners are also humans. But in the Sri Lankans idea is they should have to treat, they should not have to treat fairly. That's because they not good for the society, and therefore they think they don't think it's a huge problem. The prison issue is a huge problem. The torture in the detention center is a huge problem. The condition of prisons is a huge problem. The people don't think it. As a human rights activist and lawyers, we think that the prison conditions should be upgraded, and prison conditions and torture must be eliminated. And we think, but the common people did not. Common people do not torture. The condition of the prisons are not the huge issues, as they don't consider it. Therefore, this issue can't be, we couldn't able to make this issue as a prominent issue, as a major issue in Sri Lanka. They think other violations, they consider. But in this issue, which is especially in the detention centers, especially the detention, torturing detention centers, the people did not think, people do not think as a big issue. I think therefore the laws, if we have a lot of laws, but we can't implement it, no, we can't implement it properly, because the people, the support of the people is not there. No, the law enforcement officers and also others also comes from the people, common peoples. They have the same ideology. They have that same ideology, and they are using its powers. And also judicial officers also don't think about this. They given they give very landmark judgments, but in the Supreme Court. But when they consider when they do not consider this is a very huge one, very huge problem. Right? That's the issue. I think we have to create. I think as a lawyers, and but in Sri Lanka now, as a lawyers. Bar Association of Sri Lanka also start legal aid unit to prevent torture and assist the torture victims. It's now working, and also several NGOs also doing the same thing. We as a Right to Life Center also doing, and we have a collective called Sri Lanka Collective Against Torture. It's some kind of collective of civil society organizations to act against this kind of torture. And our challenge is to how do we change the people's mindset, common people's mindset, and make a powerful force to eliminate torture. We have to do a lot to achieve this target, I think, because otherwise the laws also we proposed, and as civil societies and other institutions and international institutions proposed the GOSL, Government of Sri Lanka, to provide several legislations, but they are now they are Torture Act and penal codes and other criminal procedure codes. So all the things we can eliminate torture by implement these laws properly, but the problem is these laws are not implemented properly. And the implementing properly comes, we have to create a pressure to the people. We have to change the mindset. That's the issue.
Yeah. Okay, Mr. Dulan, thank you so much for your elaboration. I think your answer have also stated for question number 3 and number 4, if I'm not mistaken, because the question number 3 or our next question can also be managed by question number 4. So I think this should be our last question, since it can be a mixture of question number 3 and number 4. What are the actions can be done, proposed in your own respective country, especially from your CSO? So from SWARAM, from the L2L, and also from CRCF here. And based on those actions, what should be the ideal solution, or should be the perfect solution to eradicate the case of torture in detention cells? So there should be 2 mixture questions here. What have been done, and what should be a more concrete ideal solution for this Torture Act? Since Mr. Dulan have also stated his answers here, maybe Mr. Dulan want to add more from your previous question. Maybe we just add for 5 more minutes, and then we will head on to Miss Noi Noi, and then last to Miss Farida. So Mr. Dulan, you may. Hello, Mr. Dulan. Okay, I think it's because of connection, because here I think the connection is not really good for today. Maybe we will just head on to Noi Noi. So Noi Noi, I will pass the microphone to you. So Noi Noi, if you may.
Okay, I think I really like what Dulan has been speaking. It's about mindset of the society.
Yes.
But actually, we have to change the mindset, not only from the people in the public, but also the mindset of perpetrator and also the victims. So I think the victims of torture in many situations in our country, they feel powerless due to that the development of justice system failure, and also the independence of judiciaries, and also the power of military and the police. So in the way that they feel like they are powerless. So what has been our focus in Thailand is we have the program to help with the torture victim and the family on their mental health and psychological support. So it's taking a long time and very difficult effort, but I think it's the way to build up the mindset that really talking about how to empower the survivors and how to link this survivor group with the other sector in the society. For example, the medical field, mental health field, and also very important if they can formulating their storytelling to be more powerful with the new media and with the journalists, both local and also at the national levels. Because our countries in Southeast Asia and also South Asia, we have the wide breadth of social media has been going on. So to empower the survivors and the family in order to tell the story. It could be subculture, theatering, or movie, documentary, until we have enough population that understand about the impact of torture. And it had happened in Thailand for one case. The father of 18 years old boy who were subject to the plastic bag, similar to the one that I mentioned earlier that's happened last year. But this case happened for 12 years ago. So this case has been a strategic case where the legal assistant have empowering the family to talk to the public. And we have a lot of new coverage about the case. At the time when the plastic bag was used more often, he came out and talked on behalf of the victims, bravely to talk against police and bravely talking in front of the camera, and also putting a number of the lawsuits in order to fight the justice in the court. So throughout this strategic litigation, we educate media, we educate the other victims, we also educate the judges, prosecutor, and other lawyers, and we educate ourselves that torture actually happened to one person, but it's also affect to the family, affect to community, and after all, it affects our rule of law, because torture is the beginning of judicial process, because the police want the confession, the police want more criminal names, and they want to make their performance well. So we also have to talk about effective interviewing, which is been going on in Thailand as well, the police training. And we also have another project with Association for Prevention of Torture. The name of the project is Safe in Custody. So we are trying to promote the safeguard and also trying to talk to the so-called perpetrator like police force and military in order to respect human rights and have other tools to fight the justice for damaged party. I mean, rape cases, other criminal cases, national security cases. The police and military has to find the way with the good effort to make the society peaceful, but they need to stop using violence. So the circle of violence will gradually stop. And of course, changing mindsets is difficult, but we have to do it. I think that's all from me. Yep.
Yeah, Thank you very much, Noino. So the same thing you have mentioned and also added, even from Mr. Dolan's statement, is that we have to not only change the mindset to the society regarding this, but we also have to remind also that the torture cases happening will affect not only the detainee, but also the family members from the detainee. So that is actually a very good point for us to remember the causes, the great causes for torture. Now, maybe Ms. Faridah can add on to what Noy and Mr. Dulan have stated regarding what have been done by your CSO, so Suara, maybe other CSO across Malaysia to your campaign probably, and what should be the ideal solution or what should be added towards those campaigns. So if you may, Ms. Faridah.
Right, okay, thank you. Yeah, so at present, like Suara and also like, other CSO is working on the campaign to for the government not to proceed to table the Independent Police Conduct Commission, Ipcc, that I mentioned just now, which is like the very like toned down version from the previous bill that has been drafted in 2005, which is have like more independent and have more like force in terms of law to ensure the police accountability, and also can be a mechanism to eradicate torture in detention center inflicted by the police. And also in terms of law reform or anything in relation to work or any initiative to reduce or eradicate torture in detention center. Like CSO is being actively campaigned, for instance, for the government to ratify CAT and so many others about issue on death in custody. But somehow the government doesn't really encourage or open up for the CSO to participate for in discussion or law reform process. And most of the time, CSO or any human rights movement is seen as those who are opposition bloc, group of people or anti-establishment. So for the few years ago when there's a change of the short stint of change of regime in Malaysia where Pakatan Harapan holding position as a government, there are few consultation been made for IPCMC ratification. IPCMC bill to be brought forward, and also there's a discussion for draconian law to be amended or to be abolished. They are Suara also been invited for for our surprise, because most of the time so far we've been shunned away from being being part of the group to discuss about about law reform, and our opinion will never been taken into consideration. But somehow it's just does not the process was stopped because there's a COVID-19, also there's a change of government again, and then we cannot see any progress from there. And also it seems everything has been back to square one again. And also there's another issue about detention facilities and also police lockup. Indeed, there are some complaints by the detaining authorities and police as well about they have lack of allocation by the government and lack of basic facilities. And they also, some of the police station also having they raised a complaint about having a bad working condition as well. And we believe that this issue should also be addressed. Of course, we're not saying that, well, because the police are, having a bad day, they should release their stress towards the detainee by torturing them. Of course, it's really wrong, but somehow there are so many issues about, they don't really have sanitary kind of condition, their lack of allocation for medical facilities to be provided. And also there's an issue about, lack of safety features like CCTV, for instance, whereupon this issue has been highlighted in few cases, inquest cases in court, where there are evidence to say that there's a facility, CCTV are not working in the, in the lockup and the police station, in which it's supposed to be an important, evidence, so that anything that happened in the lockup can be can be monitored. And if there's any issue about, about torture or death in custody, it can be presented in the conclusive manner. And also then for the international level, of course, we are we are hopeful that the government will agree to ratify UNCAT, so that at least there's some monitoring mechanism from the international level towards the what is the in terms of minimum standard of the detention facility, and also this can be a means to reduce or to eradicate torture by by the authority towards the towards the detainee and prisoners as well. Yeah, I think, well, that's a bit about it.
Okay, thank you very much, Ms. Farida. So there are actually the red string between what have Noi, you and Mr. Dulan have stated, the change of the mindset also from the society, but also the accountability again and the transparency from the government, not only the government as the main, let's say, actor to conduct the law inside the country, but also to give a full implementation of the UNCAT itself, like the main code for the entire government agents or just the security officers to fully implement the UNCAT. And you have also stated the reform of law, because it seems that looking at the condition today in Malaysia, in Thailand, and in Sri Lanka, or maybe to be precise, in Malaysia, from your country, there should be a matter of changes to be used from the UNCAT in your respective country. So several points here have been stated from the speakers to give their answer for question number 3 and question number 4. And that concludes to our webinar today. I think Mr. Dulan here has another activity to do, so maybe I'll just leave it to Noi and Ms. Farida to give maybe their closing statement for today's webinar from all of your elaboration. So maybe I can go first to Ms. Farida. You may give your closing statement to us regarding today's webinar and maybe the key points you want to give and hopefully be shared to the audiences. You may, Ms. Farida.
Firstly, I would like to thank the our organizer for giving us opportunity to to share about this issue at this platform, and also I've learned and been enlightened a lot from Ms. Noi, also Mr. Dulan, about what is the condition of and also the current situation about about issue of torture and ill treatment towards their detainees in their respective country. And it seems like there are many similarities as well in Malaysia. Okay, yeah. So with regard to the my to sum up, I must say that there's a lot of things to that we need to improve in terms of improving the condition of the detention facilities, and also like the rights of the detainees, whether they are like in prison or in police lockup, immigration, and apart from CSO, which like promoting human rights and been campaigning and been pushing for the law reform towards a better treatment of the detainees. We are also we also like pushing for the encourage the government to also work together with us instead of seeing us like as like sort of like enemy or the like opposing side, because like it's important for for the things to work out like in the cooperation, if we cooperate together, because like since the government is someone who's like having as authority and having access towards I mean implementation of law, but somehow and on the part of CSO and also the public, we are the one who actually having gathering the information from the from the subject themselves, and also like become the voice of those like the victim, and also the society who's actually like wish for the betterment of the society and want to have like the law to be implemented and to be like well improvised in such a way to to promote human rights. And also yeah, we hope that like moving forward we can like have a a specific law to address the issue of torture, like like what I believe that certain country is like is having. And actually like I must say that this issues or any like law reform or about the thing that we discuss is not only like victim centric. It also actually like for the benefit of the authorities or the police as well as a whole, because like if there's a proper like mechanism for monitoring, and also like if there's a law or regulation that safeguards the human right, they might they are more like I mean careful and diligent in disposing their duty. And also, well, if there's if like if this authority didn't do anything wrong, of course like there's nothing for them to care about. So yeah, I mean like actually it's a it's a win-win situation. It's like, and also it's not really like more on like towards criticizing the government per se. So it's actually like for to get the whole society to live in harmony. Yeah, I think that's all from me.
Thank you so much, Ms. Fari. That is actually a very touching, not only touching, but a very strong statement from you. Hopefully from here, I really wish that your campaign succeeds and could affect, give hope even to many family members who were the victims for torture inside the detention center. So thank you very much, Ms. Farida. Next, I will give the microphone to Noi Noi. You may, Noi Noi.
Yes, I think I'd like to thank all of us that keep moving on to a very difficult situation in our own country. And we all know that our basis of work is human rights, but the issue on torture that happened in the past 20 years, we have also to think in international arena that we have actually failed to prevent Islamic phobia, and also the impact of 9/11 that actually are coming from external influence. But because we have not strong, so have not have our strong rule of law principles. And our institution, especially in Thailand, the judiciary, the administrations, and also registration are so weak. That's why we absorb a lot of practice that's actually coming from hatred, coming from 9/11, coming from the influence from the terror, and in those who have been using violence, both government, state, and also extremists. So I think we have done our best in order to keep up giving a support to the victims, and we shall continue doing so. And also the solidarity among workers, health personnel, and also human rights work, lawyer, judges, also those in medical field, it's still going on. And I think we can be hand in hands and helping each other to stop torture gradually, and also to actually prevent all kinds of violence. Thank you.
Okay, thank you very much also, Noi Noi, for your strong statement as our closing statements for from our speakers for today. So let me close this webinar by giving a conclusion. From this webinar, we may conclude that detainees receive torture every single day across Asia, or maybe the other regions, to unfair treatments during their times in detention cells. Acts such as overcrowded number of detainees, and then the lack of certain facilities like health, or even to the point of mental health facilities, humiliation, electrocution for information and investigation, and etc. Although there seems to be anti-torture bills implemented or soon to be implemented by these countries mentioned in the webinar, but cases still to have lingered around or engaged around Asia. Now, therefore, the speakers here have concluded and suggested there should be a full implementation, not only partially, but also fully implementation of the UNCAT as our main legal proposition, since there are deviants like the security officers, and there should be also a more transparent accountability for us to know what is actually happening within the cells, and should it be a violation of deviation against human rights. The reform of law also mentioned by Ms. Farida, and to change the mindset of the citizens that torture is not just an act done by the security officers or other agents to the detainees, but it is actually also a form of violation against human rights and is affecting deeply to the family members of the detainees. So here we can conclude for our webinar for today. Thank you very much, participants who are watching this webinar. So see you next time for our next webinar. Thank you for Noi Noi, Ms. Farida, and also Mr. Dulan. Thank you very much.
Thank you.